Inside this building, 3 cases are waiting, silent, unresolved, but heavy with consequence. They don't just test the Second Amendment, they test how much power the government has over your life. In one case, the government claims it can redefine what a firearm even is, and in another, prosecutors argue that owning a gun during a crime should add decades to your sentence, even when it was never used. And in the last, a single state says you can't carry on private property unless you've been personally invited. 3 cases point 3 chances to reshape the meaning of gun rights in America. And one Supreme Court that could tip the balance forever. The question isn't just what the court will decide, it's what happens to you when they do. If you believe the law should stay clear, not twisted by politics, hit subscribe now. Because when these rulings come down, they'll decide how much freedom gun owners still have. And trust me, you'll want to know first. Let's start with the case that could redefine what even counts as a gun, and why one word in the law has millions on edge. Case number 3, Bondi v. VanDerStok, number 23-852. The case that questions what a gun really is. For years, hobbyists have legally built firearms at home, assembling parts, finishing receivers, creating what's called a home-built gun. But in 2022, the Bureau of Alcohol, Tobacco, Firearms, and Explosives, the ATF, decided that some of those unfinished parts should count as firearms themselves. That decision sparked one of the most consequential legal battles in decades, Bondi v. VanDerStok. The legal question. At the heart of this case is a single question. Can a federal agency rewrite the law to expand its own authority? Congress defined a firearm decades ago, including its frame or receiver. But the ATF's 2022 rule stretched that definition to cover parts that could become frames or receivers. The agency said it was closing a loophole. Gun owners said it was creating a new law, something only Congress can do. The case reached the Supreme Court after lower courts struck down parts of the rule, calling it legislative in disguise. For now, the rule remains in effect while the justices decide. But their ruling will determine how far federal regulators can reach into the world of privately built firearms. What's at stake? If the court sides with the ATF, every unfinished receiver, every parts kit, could fall under federal regulation. Serial numbers, background checks, and paperwork. T would mean that what used to be a hobby could suddenly become a regulated act, watched and tracked. But if the court rules against the ATF, it could strike a major blow to agency overreach, limiting how much power bureaucrats have to reinterpret the law. That would send a message. Words still mean what Congress wrote, not what regulators wish they said. Either way, the decision will ripple across every workshop, every gun show, every manufacturer. Because it doesn't just decide what's legal to sell, it decides what's legal to own. So what do you think? Is the ATF closing a loophole or crossing the line? Drop your thoughts below. I read every comment, and your take might shape what we discuss next. But if redefining a firearm wasn't enough, the next case dives deeper into how owning one can add decades to a sentence, even when the gun was never fired. Case number 2, Barrett versus United States, number 24-5774. When owning a gun can mean years behind bars. Imagine this. You're pulled over for a minor traffic stop. An old firearm is found in your car, legal to own, but you've also got a small amount of drugs. No violence, no threat. But prosecutors decide to charge you under a federal law that adds extra years, sometimes decades, simply because a gun was present, even if it never left the glove box. That's what's at the heart of Barrett versus United States. A case that asks, when does possession become punishment? The law in question, 18 U.S.C. Section 924C, was designed for armed criminals who use guns during violent or drug trafficking crimes. It stacks mandatory minimums, 5, 10, even 30 years, on top of the original sentence. But over the years, prosecutors have stretched that meaning, charging people who simply had a gun nearby. In Barrett's case, the weapon wasn't fired, brandished, or even touched. But because it was in furtherance of a drug offense, he was hit with an extra 7 years. No parole, no discretion. His lawyers argue the statute has become a weapon itself, one that traps defendants in sentences Congress never intended. The Supreme Court must now decide, does mere possession of a firearm near a crime automatically justify years of extra punishment, even when there's no proof it was used to commit violence? The lower courts are split. Some say proximity is enough, A gun near drugs means risk, and risk deserves penalty. Others say intent matters. Punishment should require proof of use, not assumption of threat. It's a question that touches every lawful owner. Because the same logic could one day apply to you: a firearm locked in your trunk, a range bag in your back seat, or a rifle in your home during an unrelated investigation. The stakes. If the court sides with the government, Barrett's conviction stands, and prosecutors keep that broad power. That means more mandatory minimums, more decades added for simple possession. But if the court rules in Barrett's favor, it could reset the standard, demanding proof of intent, not assumption. It would be a message that guns aren't guilt by association. Either way, this case could redefine how federal law treats firearm ownership. Because it asks a haunting question: when does owning a gun stop being a right and start being evidence? What do you think? Should mere possession carry heavy time, or should the government have to prove intent? Drop your thoughts in the comments. I want to hear what justice looks like to you. But our final case goes even deeper. Not into what you own or carry, but where you can carry it all. And this one, out of Hawaii, might decide the future of concealed carry nationwide. Case number 1, Wolford versus Lopez, number 24 to 1046. The Hawaii case that could redraw the map of the Second Amendment. On the surface, Hawaii seems far removed from America's mainland gun debates. But this quiet island case may soon decide one of the loudest questions in Second Amendment history. Where, exactly, are you allowed to carry your firearm? The case is called Wolford versus Lopez, and it started with a single line in a state law that flipped the meaning of public carry upside down. The background. After the Supreme Court's 2022 decision in New York State Rifle and Pistol Association versus Bruin, states were told to align their gun laws with the nation's historical tradition. Many states complied. Others found new ways to resist. Hawaii passed a law requiring that concealed carry permit holders obtain explicit permission before bringing a firearm onto private property, even places open to the public. Parking lots, restaurants, stores. In other words, every property became a default gun-free zone, unless the owner said otherwise. Gun rights groups sued, calling it a backdoor ban that gutted the Bruin ruling. Hawaii defended it, claiming the rule respected private property rights. Now the Supreme Court must answer. Can a state make your right to carry depend on getting permission first, even in public places? Supporters say the rule protects private choice. Opponents say it destroys a constitutional one. The lower court upheld Hawaii's restriction, reasoning that property owners deserve control over who brings firearms onto their land. But challengers point to Bruin, which made clear the Second Amendment isn't a case-by-case privilege. It's a right. The stakes. If Hawaii wins, states across the country could copy this model, turning carry rights into permission slips, one sign at a time. Every parking lot, store, and restaurant could become a potential felony zone. But if the court strikes it down, it would be a reaffirmation of Bruin, and a warning shot to every legislature trying to sidestep it. This isn't just a Hawaii fight. It's about whether your right to self-defense ends the moment you step onto someone else's property. And the answer could rewrite how the Second Amendment lives in public spaces for decades to come. What do you think? Should your right to carry depend on private consent, or does that go too far? Share your thoughts in the comments. I'll be reading them all after this goes live. 3 cases point 3 questions that go beyond gun laws into the meaning of freedom itself. Bondi v. VanDerStok will tell us how far the government can stretch the word firearm. Barrett v. United States will decide if owning a gun can add years to your sentence. And Wolford versus Lopez will determine whether your right to carry ends at the edge of a parking lot. When the Supreme Court rules, these decisions won't just appear in law books. They'll echo in homes, in workshops, in courtrooms, and in the lives of millions of lawful owners. The next term could redefine the Second Amendment for an entire generation. The only question left is, which way will the court go? If you care about where these rulings lead, make sure you're part of the conversation. Hit subscribe, turn on the bell, and stay with the Firearms Legal Desk, because when the decisions drop, we'll break them down first, with zero spin and full context.